Marta Vanegas, the head of the business law section, to take us into our program today. Thank you, Marta.
Thank you, Anne. Thank you, everybody, for joining us today. So this is a little bit different format. We are going to jump into character. And I am Marta, stewardess in this story. And you may know me, I'm a winemaker. I'm drinking my little fake wine here. Let me just get to the PowerPoint and introduce you to the story of our heroines and share the screen. And I'm going to do the slideshow. I hope everybody sees this beautiful slide that thanks to PowerPoint, I was able to prepare for you. Today's the part 5, intellectual property. I don't think we will have a lot of time to talk about cyber because we have so much to cover. But let's just get to the story of our heroes. So I am Marta Stewardess. I play a graduate student at the Polytechnical College of San Francisco. I'm studying chemistry. I expect a PhD really soon. My favorite movie is Sideways. And here's my favorite wine. And my hobby is I'm a winemaker. My best friend is Brittany Spearstein. She is a graduate student also at the Polytechnical College of San Francisco. Brittany could not be with us today because she's on maternity leave from the company, but she is a very talented computer science and business student and expects her MBA and MA in computer science, so double masters this year. And we met at our screening of our favorite movie, Sideways. Here's her favorite wine. It's a brew. You know, Brittany likes the finer things in life, and she loves to cook and pair her recipes with wine. And our third friend is Myra Estefan. She's also a student with us at the Polytechnical College studying electrical engineering, expecting a master's, and she's also studying to be a sommelier. We met at that famous fated Sideways screening at the college, and her favorite wine is a Malbec. So here is the story. Martha Stewart has had this fantastic idea that we can refine the winemaking process by building a device that would continuously monitor certain key chemicals during the process. The device would use sophisticated software algorithms to determine exactly what quantities of what ingredient to add at what times, and it would produce an optimum balanced wine. Brittany and I worked together to refine the algorithm and develop the software code. And then Myra produced the hardware design for the device and built a crude prototype of the device in the Political College Engineering Lab. Brittany then programmed the device, and then I tested it on the next batch of the home-brewed wine that I was making, and the results were very good. We then dubbed this device the Sideways Winemaker and created this little logo, SciY, and began holding dorm parties and featured this wine that I made with my during my home brewing process and put on this label. And we even had a cute bottle design. It was a bottle that would always be sideways, and the label would be on the bottle sideways. So there is a label, there is a bottle, there is this wine, there is a winemaking widget. So we thought this should be a business. Brittany created a web page, described the wine on the web page, and people started to take notice. Word soon got around. Other amateur winemakers began asking about the Sideways Winemaker and if they could purchase one. And that's when we definitely thought this should be a business. So we wanted to, quickly incorporate. And however, when we started this process, we were all students, but Myra was graduating and got a job offer from the East Coast in New York. So she wanted to pursue that instead of being in a risky endeavor with us here, and also she has family there, so she decided to go to New York, wished us good luck, and left. So then we put together all our savings and then got a nice infusion from Brittany's parents, and we started up our business. Now we formed 2 entities to run our affiliated businesses. If you were with us in the prior presentations, then you could hear why we needed 2 separate ones. We have a limited liability company for making the wine, and we have a corporation for manufacturing the winemaking monitoring device. So the LLC will just make the wine with the Sideways Wine widget. And the LLC will host demonstrations on how to use the widget and taste the wine. We raised funds for the corporation through venture capital. We found an industrial location in the Oakland Hills to lease, and that's where we operate the business. So we do both the manufacturing there, and then we have a tasting room and a brewing facility for our Sideways wine. And then we signed the lease for this, we moved in, and now we are talking with our IP lawyers to discuss how to secure the most valuable of our corporation's assets. So here are our counselors. Joe Snyder is the managing partner of Kilpatrick Townsend's Walnut Creek office and one of my oldest, best friend. And his practice focuses on patent prosecution and counseling, emphasizing patent drafting, patent procurement, client counseling, opinion writing, primarily in the chemical arts, biotechnology, life sciences, and clean technology. He counsels clients on planning and portfolio analysis for patent protection, including strategic review of technology's commercial potential, enforcement of patent rights, and defense of infringement allegations. He has been a patent attorney for over 27 years, not that he looks it. And we have Natasha Chee, who is the principal of law offices of Natasha S. Chee. Natasha is an award-winning entertainment and IP attorney with wide experience negotiating, drafting, and reviewing contracts for movie and music producers, authors, artists, actors, musicians whose work appear in film, television, new media, and beyond. She has extensive experience with sophisticated agreements. She is attorney of business and legal affairs, music supervisor, post-production supervisor, and co-producer for feature films that are in global distribution. She has over 15 years of experience, and she's one of my best girlfriends. So here we are in the lawyer's office, and our meeting begins with Joe. And I will stop the share. Joe, thanks for seeing me. I am super excited to talk with you about all things intellectual property. I have to admit to you that I, as a business owner, I'm a bit naive about everything that I need to know. And I just think if I have a fantastic product, then I will be able to make money. So you probably will have to disabuse me of my notions quite a bit.
Okay. Marta, so I thank you for the call. Prior to this meeting, I was able to put a few slides together regarding the Sideways wine. And I'm wondering whether or not, can you share your screen with regard to the slides, or how does that work?
I can pull up the slides that you sent to me. Just bear with me a second. And then you will have to tell me when you want to move to the next slide.
Okay, I can do that. Thank you.
I go back to share the screen as soon as it opens. It's doing the little circle, everybody. So it only takes time now. Okay. Okay, it opened and I'm going to share. And then I go here and I say slideshow from the beginning. This is very pretty. Thank you for sending.
Yes. So this is the the patents in particular in intellectual property in general for sideways wines. And basically, as probably everyone knows, there are 4 types of intellectual property, 4 buckets, and trademarks is a type of intellectual property, and Natasha is going to go into these in detail. Trademarks are basically any kind of recognizable sign, design, an expression that identifies a product or service from a particular source. So in this particular instance, Sideways Winery will be a trademark for the new LLC. I have, as Marta has put up on this particular slide that we're looking at, a trademark can be a generic trademark, such as aspirin, right, or Xerox, something that everybody uses almost like a noun, right? So that's a generic trademark. A descriptive trademark, an example of that would be like Southwest Airlines. A suggestive mark could be like Netflix or Microsoft, where it gives you sort of an idea of what the product is. An arbitrary trademark, an example would be Apple. I mean, you wouldn't necessarily associate an Apple with a computer, but so that's more of an arbitrary mark. And then a fanciful mark is an example of that is Exxon, right, where it's a completely made up word, and those tend to be like the strongest marks. But Natasha will go into detail regarding trademarks as they relate to Sideways Winery. Another form of IP is a copyright, right? And a copyright is a type of intellectual property that gives its owner an exclusive right to copy and distribute a creative work, usually for a limited time. It's the lifetime of the author and 70 years, right? And your creative work may be in a literary or artistic, educational, musical form. Copyright is intended to protect the original expression of an idea, but not the idea itself, right? And there are limitations to copyright based on public interest considerations, such as fair use. And Natasha, again, will talk about that in detail. Another form of intellectual property is trade secrets. And this is a form of intellectual property that includes formulas, practices, processes, designs, instruments, patterns, or compilations of information, such as address lists, that have inherent economic value because they are generally known or because they're not generally known or readily ascertainable by others. One thing, so here we have an example of, for example, Coca-Cola, and Coca-Cola is the actual recipe, just like KFC chicken is not known to others. And one of the requirements for trade secrets is you have to keep them confidential. So I put here on the right-hand side this top secret Mission Impossible clip that everybody kind of remembers, where after Mr. Phelps gets the secret the tape, the tape, self-destructs, right? I sometimes though, I'm just looking at a tape, as the audience gets younger and younger these days, they may not know what a tape recorder is that looks like that, right? So, but in any case, one of the benefits of a trade secret is that it could last forever, right? As long as it's kept secret. And I think the next slide, Marta, basically, we'll talk about patents, but I just wanted to show you this chart, this table, which basically compares patents and trade secrets. So, so for public disclosure, a patent, it's required to basically tell the world, if you will, what your invention is, right? So part of the quid pro quo, if you will, is public disclosure of the invention. You have to teach people of skill in the art how to make and use the invention. So a public disclosure of the invention is required. Whereas a trade secret, it's not permitted, right? It would no longer be secret. You would lose its protection if it were publicly disclosed. A patent generally lasts for about 20 years from the filing date. So you file the application, and I have a timeline later on in the talk, but you file the application, it's examined, a patent issues. The day that the patent is filed, that's like the beginning date, right? And then you tack on 20 years, and that's how long the patent is. And trade secrets, as we said earlier, could have an indefinite length of time, right? So in this particular instance, Sideways Winery has come to us looking for patent protection with regard to their Sideways widget. That probably, as we'll see, is a good candidate for patent protection. But the algorithm that one we might want to just maintain as a trade secret, right? Because that might be more difficult to patent. Are you allowed to reverse engineer a patent? Well, that's not okay, because it gives you an exclusive right to exclude others from making, using, and selling your product. So those, the public would not be allowed to reverse engineer your patented product. But a trade secret, because it's not, because it is confidential, if you were to independently discover it or reverse engineer it, that would be okay. And it would no longer be a trade secret, that's permissible. Whereas a patent, if you independently discover something that has already been patented, you can't get a second patent for that, right? It is a monopoly, and you wouldn't be able to get additional coverage on it. Okay, next slide, please. So what cannot be patented? So laws of nature or natural phenomenon are not patentable subject matter. Abstract ideas, business methods, and software claims are patentable, but cannot be abstract, right? So here we have DNA, which is a product of nature. Genomic DNA is not patentable. cDNA is patentable. Here we have a yeast up here on the right-hand side. That's a product of nature. And of course, it's required for wine making, and that's not patentable either, because it is a product of nature. All right. Okay, next slide, please. So as I said earlier, patents are sort of a legal monopoly of 20 years. And this quid pro quo or exchange for that monopoly is a full disclosure on how to make and use the invention. And then it also can be what's known as a so you can protect the functional subject matter through a patent or the ornamental design. So I have down here various types of claims. Everyone's familiar with the one-click, Amazon process. That's a patentable invention. Here's an iPhone, which is a product. That's patentable. Here's a chemical composition. That's also patentable. And then there's a design, which is the ornamental design. You can get design patents which protect the ornamental design and not the functional aspects. And those patents, those design patents are, they expire in 14 years as opposed to 20 years. Okay, next slide, please. So when do you seek a patent? Well, here's like a little flow diagram. Is it new? If it's new, you can go on to the next box. Does it enhance competitive position or market advantage? And so in this particular instance, we're asking whether the vat, the wine widget, which is sort of a vat to make wine, is that does that enhance the competitive position or market advantage? Does the chemical sensor enhance competitive position or market advantage? I would say yes, because we already have people who are interested in obtaining these apparatuses. And so it would enhance the competitive position and market advantage of Sideways Winery. So then the corporation asks itself, is this something you want to prevent others from doing? Yes, it is. So then you want to consult with an attorney or legal department for this, right? There are other reasons to do it in negotiations or cross-licensing opportunities, and we'll talk about those as this presentation continues. So there are basically what I like to say 3 doors you have to pass through to be eligible for patent protection. And the first one is it new? So it must be novel. And what does that mean? Well, it has to never before be known, right? So the invention was not patented or described in a printed publication or in public use, on sale, or otherwise available to the public. It's new, right? And Sideways Winery came up with a new wine vat as well as a chemical sensor. It passes that test. It must have utility. This is the second door, right? And 35 USC 101 says that it has to have this type of utility, and the wine vat makes wine. I mean, it's someplace to actually ferment wine, so it has utility. And the chemical sensor detects various types of chemical compounds. It too has utility. And then the last door, and this door is kind of where all patent attorneys really spend most of their time, making it through this door. And it's known as the invention has to be non-obvious. And this non-obviousness is a term of art. But what it does is there's a hypothetical person, a person of ordinary skill in the art that basically has the entire prior art in front of him or her, right? And so all the prior art for winemaking, this ordinary person of skill in the art would have available. And so the examiner, the patent examiner, sits in this doorway and doesn't want the patentee to pass, right? And it's up to us as the inventor's advocate to get through this door, because these first 2 doors are relatively simple to get through, but then this non-obviousness is the most difficult because the examiner is allowed to combine art, right? So everything that is, patentable, there's some piece of it that was known, right? So the examiner kind of picks up that piece of art and something close to the, the patentable feature, and then combine these pieces of art and say, oh, well, look, I'm an ordinary person of skill in the art. I could have easily put these two pieces of art together and your invention is obvious. And then we spend our time rebutting that notion. Next slide, please. So what are the values of patents? As we said before, they reduce competition, they strengthen bargaining power. So by creating a leverage with competitors, distributors, and customers, they generate revenue. Sideways Winery may want to license it, and it's a property asset, right? So it could be collateral for a startup. When the startup goes and looks for venture capitalists money, we say, hey, we have a patent on this, or this patent is pending. Give us money because we're going to have this competitive advantage. No other startup or wine manufacturer is going to have these nifty functional items, and that's going to make our value of wine. It's going to make the wine better, because we can optimize the wine making process. And we may want to license some of this technology to others that, we don't want them to compete with us, but we don't really envision making like a Pinot Noir. So maybe we say, okay, you can have this, you can have a license to our technology, but you have to make Pinot. We're over here in the cab space and Malbec. So we're going to be able to license this. Maybe it's an exclusive license for this particular type of grape, right? So that's some of the values of patents. So what is a bar to patent protection? Well, in the US, as in most jurisdictions, you can lose your right if it's talked about or it's published, right? Because remember those doors that we talked about earlier, right? The first one was it has to be novel. And so if you go out and do a presentation, then you can destroy the novelty of the invention. Or if it's published, you destroy the novelty. Now, the US does have what's known as a grace period, and that's a 1-year grace period. You can still file your application in the US, your patent application, despite the fact that it was publicly disclosed, if you do it within 1 year of that disclosure, right? But that might mess up your foreign filing, because this wine of course, wine is made all over the world. We want to seek protection not only in the US, but in other jurisdictions. By disclosing it, we might actually destroy our ability to go into other jurisdictions. Next slide, please. So Marta and I spoke earlier about how to keep the costs down for drafting these, and she had said that they can do all the prior art searching in-house. That's going to help matters. They're putting the technical documents together, the details, and they're going to provide all those things to me. So it's going to make it easier to draft the applications. Next slide, please. So I did a little bit of searching before she came in. I found some prior art in the winemaking vat prior art. This is a piece of prior art. It's entitled Winemaking Vat. It was issued in 1990. It's no longer in force because it's exceeded that 20 years, right? And but this is close prior art. The examiner is going to use this, but we've already kind of figured out, and we're going to talk more about the functional aspects that the sideways winery vat has that's not in the prior art, right? That makes it novel. Those are the things that will be claimed, right? And the claims of the patent are what really gives you what's known as the metes and bounds. So if you think of a analogy to real property, then it's the boundaries, right? The actual the claims to the patent are the boundaries to real property, right? So it's like what the patent covers, and that's the claims. Okay, next slide, please. In addition to the chemical vat, there's our winemaking vat, there's a chemical sensor. These chemical sensors allow for the detection of alcohol, specifically ethanol. It also detects tartaric acid. It detects sugars such as glucose and fructose, and then phenolic compounds such as tannins, right? So this chemical sensor, as my understanding, is very sensitive and is able to look at these various constituent parts of the wine to optimize the winemaking process to there's never a bad vat of wine because they have this chemical sensor, which basically, as long as we have all these constituent parts within these ranges, we know we're going to get a good bottle of wine. And so that's what, is so superb about, that's why all these winemaking critics are loving this thing, because all of these parts, all these chemicals are optimized in the sideways wine. Next slide, please. I'm just being cognizant of the time. This is a timeline, right? So we're still right here. We haven't filed our provisional application, but we think we're going to be able to write it and put it on file in about 3 months. It gets filed 12 months after the provisional is filed. We decide to file in the US, but because wines are all over the world, we're going to file a PCT application, which is like an international application. That then is published 18 months from the provisional date. So the whole world will know about it. But then at the 30-month date, we're going to file in Europe and Japan and China and the US. And we're going to start getting our patents in 50 months from the original one. So so it's going to take 3 to 4 years to get patents in all these jurisdictions, but it's going to be well worth it. We're going to have the market on this vat as well as the chemical sensor. Next slide, please. So these are some of the the wine critics saying, yeah, this is great stuff. Marta and I had already talked about this. The technology behind this may not win a Nobel Prize, but it's clever enough, it's far enough from the prior art that I recommend that we patent it, right? So next slide, please. Maybe I'll stop right here just to ask anybody if they have any questions. That's a lot of material, but I'm happy to.
So I don't see the Q&A while I'm doing the screen share. So maybe we just need to go through the slides and then I can look at what questions are posted.
Okay. So
I don't see any questions in the chat, nor are there any in the Q&A.
Okay. Thank you. Thank you, Anne.
So maybe what we'll do, Natasha needs, it's 20 minutes left. We can come back to these startup scenarios, Marta. I'll let Natasha, go over her her presentation, and then time permitting, we can come back to these scenarios.
Sure.
Hypos. Okay.
Natasha, the screen share is yours. Thank you
Okay,
so much
awesome.
for
Thank you
seeing
so
me.
Let me see here. Okay, is that working?
Yes.
Okay, great. Sorry, this time of day, I look kind of green in this room, so I apologize for that. All right, so let's. Oh. All right, so there are 4 ways to protect intellectual property, as Joe had mentioned, and he did a really good job of explaining all the different ways to protect your intellectual property. And so I'm going to go over primarily copyrights and trademarks during this presentation. And copyright is the protection for original, creative, or artistic works. And trademark is for protection of your rights for brand names, slogans, or logos. So what is a trademark? A trademark can be any word, phrase, symbol, design, or a combination of these things that identifies your goods or services. As you can see in the background, there are lots of very recognizable marks, even though some of them are covered up. Even the smallest pieces of it, I think you can tell what companies these and brands that these are referring to. So trademarks are used for goods, whereas service marks are used for services. They must be used in commerce. That's one of the requirements. And it also must focus on the consumer, as in the fact that it acts as a source identifier. All right, so the purpose of a trademark, as I mentioned just now, is to identify the source of your good or service. And this is what makes the mark inherently distinctive. It provides legal protection for your brand. It essentially puts people on notice that you are asserting your legal rights for this symbol or logo or et cetera. And it helps you guard against counterfeiting and fraud so that people know this is a genuine, Gucci bag versus maybe a questionable bag of lesser quality and design. So this is the spectrum of inherent distinctiveness. The low end, it starts with the generic, and then it increasingly becomes stronger. So it goes generic, descriptive, suggestive, arbitrary, and fanciful. And Joe touched upon these, so I'm not going to go in depth, but generic, which would be impossible to register, is aspirin. Descriptive is something like our open MRI system, which completely describes what the product or service is about. Suggestive is something like Coppertone, where you sort of get what it's about. Perhaps it's about protecting you from the sun or making you tanner. Arbitrary is Apple, which does not sell apples, does not refer to the fruit apples. It's about computer products. And fanciful, which is a name that is completely made up and has no reference to anything, so such as Kodak, which makes it easier and stronger to register. All right, so here's a flow chart based on that spectrum. So as you can see, so generic is not distinctive, so it's not protectable. Descriptive, so this is interesting. Descriptive, if it has not acquired secondary meaning, which I'll go over a little bit later, it's not distinctive and it's most likely not protectable. However, descriptiveness can acquire secondary meaning, which then can afford it distinctiveness and then protection. So suggestive can then become distinctive and protectable, and arbitrary or fanciful is distinctive and therefore protectable. So trade dress is a type of trademark. It refers to anything that is designed or used to promote a product or service, the total image or overall appearance of the product or service. Here is an example of a Coca-Cola bottle. It is distinctive in its appearance and image design of the bottle. The requirements are that it is used in commerce and that it is non-functional. So the wavy body lines of this bottle are not functional. It does not provide any functionality for the Coca-Cola. It doesn't make it taste any better. It doesn't make it easier to ship, etc. And the distinctiveness of it must be there as well. So for something like sideways wine, sci-wi, I think Marta had contemplated making an interesting bottle shape where the bottom of the wine bottle, of a traditional wine bottle, would be flat and the rest of it would be traditionally round. That could potentially be something that you could apply for a trade dress. However, if it's functional in the sense that it can lay down on one side of it, then perhaps it may not qualify for trade dress. So Marta, maybe you can find some other way to make the bottle shape, distinctive and qualify for trade dress, which is not functional. Maybe the neck of the bottle can tilt sideways. I'm not sure. That probably won't be very functional in terms of shipping, but it's completely non-functional in terms of design. All right, so we have a case here. It's Christian Louboutin versus Yves Saint Laurent. And I'm not sure if everyone is familiar with these two brands, but most likely if you're into shoes, and especially women's shoes, these brands are very well known. So Christian Louboutin on the left here always puts this red color on the soles of their shoes. And they asserted their trade dress against Yves Saint Laurent for the shoe on the right, which was a monochromatic red shoe from the outside all the way through to the sole. And Christian Louboutin actually acquired secondary meaning of their red soles because it was the primary significance of a product feature, which is to identify the source of the product rather than the product itself. I think if you ask a lot of women out there, which is the consumer, hey, if I show you just this shoe with this red sole, do you know the source of it? And perhaps many women would say, yes, those are Christian Louboutins. So pursuant to Section 37 of the Lanham Act, 15 U.S.C. 1119, the court limited the trade dress protection to the red sole on a shoe of a color other than red. So YSL's use of a red sole on a monochromatic red shoe did not infringe on the red sole mark. So this was a very interesting case. So if you wanted to make a red shoe with a red sole, that would be okay and not infringe upon Christian Louboutin's trademark. All right, the Lanham Act protects trade dress. So the Lanham Act, 15 U.S.C. Section 1051 et sec. Is a federal statute that governs trademarks, service marks, and unfair
I'm
competition.
in the middle of a program. What do you need?
It protects trade dress if it, it protects trade
No.
dress.
Hold on.
If it's,
Let's say.
And
can you please mute? Okay, if it serves the same source identifying function as a trademark, it is possible to register a trade dress as a
Okay,
trademark.
So what does she think's wrong? The lab, what was the issue?
One second. It is possible to register trade dress as a trademark, but for practical reasons, most trade dress and product configurations are protected without registration under 15 USC section 1125A. False designations of origin, false descriptions, and dilution forbidden. So for example, I had shown you the Coca-Cola bottle. They actually never applied for a trademark, trade dress for that. It has acquired distinctiveness, everyone knows it, and so they have protection regardless of the registration. However, if you do register trade dress, after 5 years, it is an automatic protection. All right, here. So this is the trademark registration process. So under common law, it requires use in commerce and distinctiveness, and the priority is limited to the geographic zone of use. So if Sci-Y and Sci-YY were only used in Contra Costa County, it would be, limited to that geographic zone of use under common law. Federal registration, however, requires interstate commerce and distinctiveness. So Sci-Y would have to sell their products or use the Sci-YY in interstate commerce. And then also this provides for nationwide priority and presumption that the trademark is valid. So the duration is as long as the mark is used to identify the source. And as you can see here in the top right corner, we have the different symbols. The R with the circle is the registered trademark. The TM is the unregistered trademark. And the SM is an unregistered service trademark. And if you go around and you pay attention, you'll see different products that use the various symbols. And there are some products out there from very big name companies that use just the TM. And why are they not an R with a circle yet? Well, they're trying to assert their trademark, and they're trying to use it in commerce, and they're trying to get that, distinctiveness. So in the meantime, they're asserting their trademark under common law until they can qualify for the federal registration. And here we have the trademark registration process. So we have the application, and usually you have to search for the trademark to see if it qualifies and it's not infringing on different things. And also there are different classes of products and services. So if Sci-Y wants to just, apply under the class of wine for wines, then they can do that. And if there's no other Sci-Y in the class of wines, then they can do the food, wine. However, if they want to start putting their marks on t-shirts and wine glasses and hats and sell those, then that would be under a different class, such as t-shirts and clothing. So there's the examination process, and then there's the public to examine to see whether there are other marks that it would be infringing upon. And then there's publication, which puts it in the public notice so that anyone can see that this is trying to get trademark registration. And then once that all is okay, there are no other infringing marks, no one is saying that you're infringing on my mark, then it goes through registration, and then you'll get your registered trademark. So Sci-Y and Sci-YY possibly be trademarked. Possibly the winery name, most likely, since Sci-Y and and also the widget name, Sci-YY. If there are no other wineries out there named Sci-Y, and it's not just the exact spelling of it, it's also something that could be similar sound. So you have to be cognizant of that and be aware there could be Sci-Y like PSY, WYY or something like that along those lines. And that would sound the same as Sci-Y, and then it would infringe on their mark. So we have to also check for those kind of possibilities when we're doing a search. The logo, name of the individual wines, if requirements are met, if there's like a wine, I'm not sure, Marta, if you've come up with some individual wine names, but If you call it like psycho, sci-Y, you know, then we'd have to look at psycho, sci-Y, and all of those kinds of things. So, but if you just call it like Cabernet, that's pretty generic. It probably wouldn't meet the requirements. And then also for trade dress, you know, the overall appearance of the packaging, the size, shape, color, layout, text of the label, and the shape of the bottle, or any distinctive, you know, characteristics of the bottle. I think you've all seen bottles that have like sort of raised or textured glass, you know, or the bottom of the bottle looks like a rose. All of these things can become possibilities for acquiring a trade dress. All right, so now we're going to the copyright section of this presentation. This protection for authors of original works of authorship fixed in any tangible medium of expression. It must be original and slightly creative. Copyrights can be afforded to literature, musical compositions and lyrics, choreography, motion pictures, sound recordings, architectural works, software, etc. So copyright authorship protection and registration. Authorship, it can be the person or persons who create or creates the work. It can be an employer, can be a work for hire. Author is the owner of the copyright unless it is a work for hire or ownership is assigned to a third party. And automatic protection. So when an original work of authorship is fixed in a tangible medium of expression, it gains automatic protection. So benefits of registration with the USPTO office is federal copyright protection against infringement lawsuits, special remedies for infringement, civil remedies and criminal sanctions. You know, you can get an injunction, preliminary injunction. You can have impoundment and destruction. You can have damages, court costs and attorney's fees, and criminal penalties. Copyright duration. So this depends on when the work was created, published, and or registered. So it's a little bit complicated here and there, depending on when the work was created, etc. So you know, whether it was created by one or more individual, an employee, or at the direction of another person or company also affects the duration of the copyright. But generally, it's the life of the author plus 70 years, then the work enters the public domain. And once it's in the public domain, use and copy of works do not require any author's permission. All right. And are wine labels eligible for copyright? You know, so purely factual or utilitarian expression is not protectable. And labels require a higher degree of originality than other creative works. Most of what a label contains is factual information, and expression dictated by utility is not protectable. And here I have some examples of some wine labels. And you can see it has, you know, it's informational in the sense it tells you the name of the winery, the name of the wine, the year, where it came from. So most wine labels include some important and useful facts about the wine on the front and back label. Earlier, I just said, you know, wine name and or dates, the brand, the actual variety or wine blend, credit to the actual winery, wine and vintage, or the winemaking process description. So depending on how original or creative these things are, in terms of like the font, if it's like a raised font or it's gold, or all of these kinds of things will make it easier to get copyright protection. Such things as the winemaking process description, that will most likely get copyright protection because it's an original creative work describing the winemaking process. So here we have a court case, US Supreme Court in Feist Publications, Inc. versus Rural Telephone Service Company, Incorporated. The originality requirement is not particularly stringent. Other courts have protected labels such as pledge furniture polish. And the more creative the label, the more likely the creative aspects will be copyrightable, and the more likely the entire label enjoys copyright protection. It's possible that the Copyright Office would limit the protected portion to only the words themselves or certain elements as well. All right, so I have, Marta, some examples for you in case you haven't figured out your wine label yet, or you're thinking of, how do I make this more creative? How do I make this more distinctive? So I'm going to go through really quick, but you'll see there's different ones. So this is the classically themed wine label. And as you can see here, there's an illustration or coat of arms. It has a white, pale, or black background. It has a serif style or cursive font, a subtle use of color, outlines or decoratively cut corners, lots of open space. So what elements could be copywritten? I mean, that image looks pretty cool. And that looks like an original work of art. So that would probably be able to get copyright protection. The font is kind of interesting here. And then also the name. So, you know, you can see where you can be a little bit more creative or less creative. 2007, I don't know. That's just the number, but maybe the use of the color, you can say I'm protecting this use of the color with this Ornelia brand. And then also here, so we have the fun and silly themed wine label. We have a satirical name and it's a very interesting font. And we have this image of this character, you know, squeezing the grapes straight into their mouth, and it's the use of bright colors, and the images and text sort of fill the space and it's more bold, and then we have this handwritten text at the bottom. So this seems a little bit more creative in some ways, but you know, this one has that beautiful image that is definitely distinctive. Okay, and then we have the modern themed wine label. We have a use of typography or a bold pattern. It's got an asymmetrical design, which makes it, I think, more artistic and more creative as well. It has this negative black backspace and black space, and then distinctive font choice, and also bold font color or bold background color. It's also very eye-catching, in my opinion. All right, we have the old-timey themed wine label here. We have emblems with filigree, words like original, established, oak age, double, cross, and last, bold classic style font. The label itself is not rectangular. It has this curved line, and it has it follows the seal. It uses different fonts. It's got this high contrast. So this is, you can see the creativity in this wine label too. Marta, which wine label appeals to you?
Definitely the modern. The original design that we had was modern, kind of an watercolor blurring of grapes and the sideways wine bottle, and then just our logo and the year of the wine on it. That was when we only used the winemaker to make one wine, so we don't really know where to go with it, but this is food for thought. Thank you so much.
Yeah, and I think, you know, it's possible that you can have different ones for different varietals as well, and maybe you can have special limited editions and use different looks. You know, it's up to you. It's a fun creative space here.
So what about our website?
All right, so yeah, the website can also be copywritten. So I have a little recap here. What can be possibly protected under copyright law? So the winery name, wine descriptions, elements of the wine front label, the back label, description of the wine, vineyard history, process. Those are most likely going to be able to be copywritten. name of the individual wines, if the requirements are met, you know, if you call it Psycho Sci-Y or Cabby, Cabernet, Sci-Y, then that's better than just straight up Cabernet. Any original text, if you talk about, you know, the history of your coming together to create this winery, this wine, this widget, the website text and images and layout, and then also the software for Sci-Y widget can be copywritten. The copyright registration process allows for software as well.
Thank you. Do you have more? Woohoo.
This is it.
Yeah. Okay. So let's go back if our audience permits. Would you please stop sharing so I could share?
Yes. Thank you.
Okay. And then we can go back to Joe and take a look at these hypotheticals.
Okay, well, thank you, Marta. Thank you, Natasha, for that. So startup scenario number one. So one of the requirements, as we talked about earlier, is for patentability, is a person is entitled to a patent unless the claimed invention was in public use or on sale or otherwise available to the public. So Sideways Wines wants to sell its wine vat to Deep Pockets Inc., right? The patentable aspects of the wine vat are the manufacturing process and the software code and the chemical probe, which measures the temperature and the wine components. Sci-Y meets with Deep Pockets to discuss selling its wine vat under a non-disclosure agreement. Sci-Y brings a prototype to show Deep Pockets. Sci-Y does not share how the wine vat works with Deep Pockets. So an offer to sell, even if it's confidential, is considered a disclosure, which starts the patent clock ticking, right? So what should have happened here, instead of meeting with Deep Pockets under this NDA agreement, is Sci-Y should have filed on the wine vat and the chemical sensor prior to meeting with Deep Pockets. Because as you know, a public disclosure, even if someone cannot reverse engineer it, you know, is a public disclosure, right? And so it would be better to have filed the patent application to prevent this this meeting being unprotected, right? Okay, I have one more scenario on the next slide. Sci-Y wants to partner with Assembly Corp to manufacture its smart wine vat. Sci-Y has not filed any patent applications on its wine vat. Assembly Corp may improve the manufacturing process because you know they're knowledgeable in this area. So ownership of any improvement or manufacturing process might be unclear. So if any issues, future issues, could be prevented if A, Sci-Y would file a provisional application, and B, you know, be under contract. So if Assembly Corp does come up with a new or some improvement to the manufacturing process, by contract, Sci-Y would own it, right? That's basically where we want to end up. So, you know, these are just some things to think about. That may be the last slide, Marta. I don't.
There is your. I have one question for you, though. We got a letter from the university, the Polytechnical College, threatening us with legal action because we developed something in their lab. Is that right? Can they threaten us with legal action? Can they make a legal action against us? And if so, what do you suggest? I'm just going to stop this though.
Right. So Yes, so California Employment Code basically says if you use your employer's facilities or manufacture or just equipment, in making your invention, the employer does have a right to that invention, right? And most states have similar code. So, what I would do is I would negotiate with the university, to either have them assign any rights that they may have. Hopefully, they'll just, you can pay the money and they'll assign it to you. It seems like it's outside, they're not in the business of putting wine vats together. It was unfortunate that we, built the prototype there and tested it. Probably they would, if we offered them money, they would probably just, assign us any rights that they may have.
Thank you, Joe.
Yeah.
Natasha, if you would mind coming back to the scene a little bit, I have a question for you as well. Hello.
Sure.
It's-
Hi.
Yeah. My question is, we got a letter from Sideways the movie.
Uh-oh.
Yeah, to cease and desist using their movie title. I don't know if the movie title is protectable subject matter or not, but I want to offer them a deal instead of having a lawsuit. What can you advise me on that?
Yeah, let's call the license or the owner of Sideways Movie, and let's see what we can do to strike up a deal where we can license and maybe do a collaboration, and then it would rejuvenate that movie as well for them, and would be more inclined to do a partnership with you guys.
But is the movie title protectable? Just a one-word title?
No, the movie title Sideways alone is not protectable, but it has since acquired secondary meaning. So, yeah, it's possible that they
have commercial rights to the brand.
Yes,
Right.
definitely. And definitely Sideways Movie, would be more protectable because you're identifying it's the film. So, but you're not making a film about wine, you're selling wine itself. So it might be in a different space.
And making wine and talking about wine and drinking wine. So thank you so
Right.
much for
Yeah.
your patience with my questions. I have learned a lot. Thank you everybody for being here today. If you have any questions, please let us know in the chat. I don't see the chat for some reason.
I don't see any questions.
I don't see any questions in the chat or in the Q&A. So I guess nobody has we answered everything.
No, I was
And
just going to
Wolf.
say thank you.
Oh, I wanted to say one more thing. So next event is in 3 weeks. It's on the 24th. And contrary to the announcement, James Wu has another obligation work thing that he has to attend to. So it's going to be Maggie Grover presenting on employment law. You know me, I'm going to make this hypothetical go absolutely bonkers for employment law. So it's going to be super fun. And then comes 7 and 8, we will go bankrupt for a little time. And then maybe we will get out of bankruptcy with the reorganization, just so that we can rebuild ourselves and sell our business in the final. So that's going to be 7 and 8 coming to a theater near you. Have a nice little light glass of fake wine with me and have a fantastic afternoon, everyone. Thank you.